Swayam Prabha. Digital India. Educated India.
Welcome students in the class of Transfer of Property Act. Myself Dr. Amarendra Kumar Ajit from Faculty of Law, University of Delhi. This is my 7th lecture in which I am going to discuss doctrine of election and apportionment. In the last lecture I have discussed the conditional transfer. So, in this lecture my focus will be mainly on these two concepts, that is doctrine of election and apportionment. So, one by one I am going to tell you about it. So, first of all come to the doctrine of election. So, this topic doctrine of election, it is mainly based on principle of equity and it is related to the same transaction and apportionment. So, first of all this principle is based on that a man cannot blow hot and cold at the same moment of time. Okay. That means there must be one thing at a time, and in that way this section 35 of TPA talks about doctrine of election, mainly when it used to come, when it is required doctrine of election. It is not necessary that in every transaction this doctrine will come, but certainly there may be certain transaction where doctrine of election will become a necessity. So, what are the nature of the transaction, what are the modes of that transaction, I am going to discuss about it. So, if you go through the nomenclature of this doctrine itself, it says election. Election means there is option to choose. Okay. So, availability of option in the document of transfer. If you are going to choose one thing in lieu of other one, then you will have to take the another one also. In that way it is. So, section 35 is very clear about it. Okay. So, it says election means choosing between two inconsistent or alternative right. So, in any instrument, if two rights are conferred on a person in a manner, one right is in lieu of other, he is bound to elect the proposal on whole or reject on whole. In other words, he can elect only one of them. That means he cannot choose at a time what is beneficial for him, and he will not choose what is this harmful for him. So, if something is an instrument which is going to give benefit to the transferor, then he will be bound to act accordingly, he will choose accordingly. So, both the things will come together in that. So, person cannot take under and against the same instrument. Okay. So, foundation of the doctrine is that the person taking the benefit under an instrument must also bear the burden of that. So, whatever it has been given in any instrument, one part is beneficial and another part is in the form of burden. So, if he choosing out of this profit and burden, if he choosing the profit part, he will have to take the burden part also. Otherwise, he will have option that he may not choose anyone. So, it will remain as it is. So, 35 is very clear that whenever you are going to choose, whenever a person is going to choose the beneficial part, at the same time he will have to choose the burden part also. So, I am going to discuss now section 35 in detail. Okay. So, what is the basis of it? This doctrine is based on the case of the Cooper versus Cooper. Okay. So, in the simple word, it has been said the person utilize the benefit of an instrument also has to carry the burden attached, and it was held in Codrington versus Codrington by House of Lords. Okay. What it has been said by the House of Lords? The doctrine contains the principle that exercise of a choice by a person left to himself of his own free will to do one thing or another binds him to the choice which he has voluntarily made, and is founded on the equitable doctrine that he who accepts benefit under an instrument or transaction of his choice must adopt the whole of it or renounce everything inconsistent with it. Thus, it is a general rule that a person cannot abrogate and reprobate at the same time. Okay. So, this is the fundamental rule. You can see the year of this case itself. It is 1857. Okay. So, certainly it is prior to the Transfer of Property Act itself. This doctrine was developed, and this doctrine is a kind of doctrine of equity. That means, this law try to give a justice through the basic fundamental principles of equity, that no, if you are going to choose something which is beneficial for you, in the same instrument if there is which is going to create certain obligation, certain burden, certain duty, in that case that will be also taken by the same person. He cannot reject one and accept other part. He can reject all, he can accept all, but there will be no choice in that way. Choice is only whether you want to accept it or whether you want to reject it. It is not the choice here. Doctrine of election, it does not say that okay, you will elect only beneficial part and you will not elect the burden part. That is not the case. Election is that you are going, whether you are going to with the this instrument or not, whether you are accepting that transfer of property instrument or not. If you are accepting it, then all things go with that. If you are not accepting, nothing will happen, nothing is going to come. So, that option is available whether you accept the transfer or reject the transfer, but once you are accepting the transfer, within that there is no option available in this case. So, condition precedent for equity of election as held in the case of Dhanpati versus Devi Prasad. Okay. Condition precedent for equity of election, what are those? A transfer of property by a person who has no right to transfer. If you go through the section 35, the first condition is this itself: as part of the same transaction he must confer some benefit on the owner of property, and some owner must elect either to confer such transfer or to dissent from it. So, in that case this has been said by the Supreme Court, which is already in section 35. I am going to discuss one by one in detail later on this essentials. So, House of Lords articulated this doctrine in case of Cooper versus Cooper. Okay. What was the opinion of House of Lords about this? So, Lord Hathor explained the concept behind the doctrine of election. What he said, that there is an obligation on him who received a benefit under a will or other instrument to give full effect of the instrument under which he received a benefit. That means, keep in mind, obligation on him who receive a benefit under a will, okay, or other instrument to give full effect to the instrument. So, giving full effect is necessary, okay, giving full effect is necessary. So, which he receive a benefit, and if it is discovered that the instrument purports to affect something that was beyond the donors or settlers' ability to eliminate, but to which effect is frequently given by concurrence of him who receive a benefit under a equivalent instrument, the law will impose the requirement on him to receive the benefit. Okay. So, the main crux of this doctrine of election is that whenever you are receiving it, then receive it as a whole and things will go as a whole. When you are not opting it, then nothing is going to come which is in the instrument. So, example has been given here that by a deed A gives to B a house belonging to C. It is very important. A gives a house belonging to C. That means, owner is C, A is just mere like an agent, and A is going to give to B, and by the same instrument gives other property belonging himself to C. That means, A is going to give the property to B and himself property he is going to give to C in that instrument. So, just like it will be a consideration for the house of C to that consideration will be paid by A. So, C is entitled to A's property only upon the connection of C's conforming to all the provision of the instrument by renouncing the right of his own property, because when he want to take the property from A, then he will have to give his own property to Mr. B. So, renouncing the right of his own property given in favor of B. So, he must consequently make his choice, or as it is technically termed, he is put to his election, that he will have to make choice whether he want money of A or not. If he want money of A, then he will have to give his own house to Mr. B. So, this is the election, and here A is going to give his own property to C, because the consideration for giving a house to Mr. B is the property which is going to be given by Mr. A. So, if he is choosing to take the property from Mr. A, he will have to release his property, relinquish his property to give his property to Mr. B. So, this election should be done whether he want to go with this instrument or not. Okay. To take either under or against the instrument, if C elect to take the instrument, he must relinquish in favor of B his property given to B by A, take the property which is given to him by A. Okay. So, in that way election works. So, this is through diagram that this transfer A is going to transfer property to A is going to transfer this money to Mr. B, benefit of 30,000 rupees. B is the real owner of the property. Mr. B is real owner of property, whose property worth is of 20,000. Okay. So, this 10,000 benefit is going to be given by A to B, that 30,000 I am going to propose it. Okay. And here A, this C is the transferee, C is the transferee. So, when A will give this 30,000 to Mr. B, okay, that this take Mr. B, this is your this 30,000 rupees is going to be given by transferor, and this transferor is a mere agent. He is transferor, but not the owner. Okay. So, and transferee is C here. It is just this is not based on the earlier example what I told you. This has been this diagram is different. So, do not correlate with the earlier illustration A, B and C, because in that Mr. C, A was the agent and C was the owner and B was the purchaser. Here the B is the owner and C is the purchaser and A is the seller. Okay. So, what will happen? A this property which is of B is going to be given to C. He will give property to C, and this property when he is going to give, then this transferor is going to give it to B in that way. Okay. So, actually C is receiving this property from Mr. B and A is transferring that one. In that way, this relationship, who will have option? Option is vested with Mr. B. Why? Because B will have option whether he want to take this money or not. If he want to take this money, then he will have to give his house or property to Mr. C. Okay. So, in that way it works. Why? This transferor is here in the form of only agent, that he is going to give consideration for this transfer to Mr. B. In that way it works. Okay. So, this is doctrine of election. Here election is available to B, whether to take 30,000 and deliver his property to C, or otherwise no transaction at all. This is the option of election. Okay. So, this has been already explained it. Now, come to the essential condition of doctrine of election. What are the essential conditions? Okay. So, according to section 35, where a person professes to transfer property which he has no right to transfer, take in mind this is no right to transfer. Okay. And as a part of the same transaction confer any benefit on the owner of the property, then such owner must elect either to confirm such transfer or dissent from it. If he dissent from it, he shall relinquish the benefit so conferred, and the benefit so relinquished shall revert back to the transferor or his representative as if it has not been disposed of. So, these are essential, 5 essential, main essential is up to the 3 only, 4 and 5 are consequences. Okay. But I will also discuss, because without consequences it will be difficult to understand. So, it has been mentioned here. So, first of all, come to the point number 1. Transferor professes to transfer property not his own. Okay. Under doctrine of election, it is not necessary that the person should be the owner. What is the meaning of professes here? That means he is the proposer of that transaction. Okay. He is the proposer. Generally, in the real estate business, we used to see that the agent do all this work. Okay. So, sometime agent merely they are facilitator, and sometime agent are actively taking the interest and they are purchasing the things, and by saying that okay, we will sell you on your behalf, and once this sale will happen, then we will return that money. So, this is the second type of condition, that suppose take the example that I have a old flat, I want to sell it. So, I will not sell directly to the buyer, I will give an option to the agent, real estate agent, that okay, my quoting price is this one, I need that much, and try to sell it. So, what the agent will do? Agent will always keep his own price in the market above to the my price, because he won't take benefit out of that. So, suppose I have offered him flat price 1.5 crore. So, he will must keep that price in the market up to 1.6 or 1.7 crore rupees. So, that will be his margin. Now, he will deal on the basis of this. Okay. So, this he is not the owner of the property, he is the proposer. So, section 35 does not require that kind of things, that there must be owner in the transaction. So, professes means purports claim or acknowledges. Okay. Such a person is not the owner of property, therefore, he cannot transfer the property, but he can make arrangements for transfer of the property which he does not own. So, it is not necessary that transferor should mention that he is transferring the property which is not his own. There is no requirement of such notice in for the purpose of election. That is, he will never disclose, or he is not duty bound to disclose that he is not the owner of the property for the purpose of election only. Okay. So, the knowledge of the fact that the transferor has no authority to transfer the property is immaterial for the applicability of the doctrine of election. Okay. So, for the purpose of election, who is going to give offer, okay, whether he is the owner or not, whether he is the mere agent, the nature of the proposer, nature of the person who is not the owner is not necessary to be known. Okay. So, that is not a essential criteria in this. So, first keep in mind that in election, owner is not the proposer. Bayer Act language is very clear that the transferor possesses to transfer the property not his own, because this is the language of Bayer, not his own. So, if the transferee is if the owner is doing this, then there is no question of option, there is no question of election, because he is the proposer and he is knowing that what I am going to sell in the market and what will be the consideration for it. Okay. So, at that time there is no election, there is no choice available. This is the quid pro quo between two persons, but here in the case of election 3 parties are involved. Okay. So, in 2 parties transaction, election is not possible. Okay. So, always there is a requirement of 3 persons. Next essential is benefit conferred on owner's property. Okay. Benefit conferred on owner's property. So, it says that the transferor, who is the agent here, transferor in the same transaction of the transfer of property confers some benefit on the owners of the property. That means, who is the transferor will propose certain benefits on the owner of the property, because he is going to sell it. So, now the owner is ready to sell the property. So, what the owner will get? So, for that purpose there is a requirement that certain benefit must go to the owner. So, this is the second condition, that owner must get something in that instrument. There must be certain benefit clause within that instrument, then only he will release the property. Okay. So, no one can release property without the consideration, without the benefit. So, it is the second condition which say that owner is one who is put to election. Okay. The person who is going to, here it has been said for this purpose, that the owner is one who is put to election. That means, the who is going to choose that whether he will continue with or not. Occasion for election arises only where the benefit is confirmed directly on the owner of the property. Okay. This is also a condition within the owners of property itself, that this second essential will only arise when there will be election or benefit here, it is going to be given directly on the owner of the property. If it is indirect, then this condition will not apply. So, where the benefit is indirectly, no duty of election arises. An example has been given here, that when A professes to transfer the property to B, transfer of property to C and gives 10,000 to the wife of B. This is not the case of direct benefit of B, and thus B has no duty to elect. Okay. That means, A is a proposer to transfer the property of B to C. That means, property is going from B to C through the help of A. But what is happening, that now the A is going to propose this consideration to the B's wife. So, if he is proposing to the B's wife, that means wife of B is not a direct person, she is indirect one, she is not the owner of the property. So, in that case B will have no right of election. Okay. He cannot choose that one. Next is that the third essential is that this election what he is going to choose and this what benefit and burden both must be of the same transaction. This is necessary that within the same transaction it should come. So, it is necessary that both the transfer and benefit form part of the same transaction, that it transfer and benefit are the part of the same transaction. Benefit must be given in lieu of transfer. In lieu of transfer, that means it is a kind of consideration, because the person is transferring his property, then he needs something. So, proposer is proposing both the things. Proposer have a two parties, one is the owner, another is the purchaser. Okay. So, here you can say seller and purchaser. So, seller is selling his property and purchaser is going to purchase, but the proposer who is a transferor here, he will make a proposal in the same instrument that okay, I am going to give this one to this this much amount for your property, you transfer this to that one, you will have to transfer to Mr. C, and in that way B will be bound to transfer this property if he is going to take money from me. Okay. So, all these things should be of the same transaction. Sometime it may happen that in some cases there may be different instrument, that something has been said in the instrument A, something has been said in the instrument B, but in all these cases if they may form the part of the same transaction, because it may be related to that transaction only. So, even though instruments are different, but they may form the part of the same transaction. There is a vice versa also, that is something may be written in a single document, but they may be the part of different transaction. Okay. So, what is the condition? Condition is that this election will be available only of the part of the same transaction if they are falling, that options are falling within the category of same transaction, then only that option can be elected. So, it has been said in Muhammad Afzal versus Ghulam Qasim. So, what was happened in this case, that after the death of Nawab of Tonk, the government, while transferring chiefship to Nawab eldest son, okay, Nawab eldest son was entitled to carry forward the legacy of Nawab, transferred some cash allowances to the Nawab's second son. That when the government was transferring chiefship, then the second son also got cash. The Nawab had already transferred in his lifetime villages to the second son for his maintenance. That means, Nawab has also transferred that to the second son, and the government has also given some amount of cash to the second son. So, it was held by the Privy Council that since these grants, that is cash and villages, came to the second son from two different sources. Okay. So, they were not the part of the same transaction. So, when they were not the part of the same transaction, in this case there was no requirement of election. That means, there is no requirement of election in this case means what? That both the property will go to the second son. That means, second son is not required to choose either cash or villages. Okay. So, they are the part of two different transactions, and in that way both property will vest to the second son. So, this is the third essential, that agreement, whatever agreement is there for this benefit and burden, all should be of the same transaction, of the same within the same transaction it will come. Document may be separate, that is not a problem, but it form the part of the same transaction. Next is owner profit must elect, owner of property must elect. What is this? Is the now choice, because now it is in the same transaction. So, owner of property will have to elect. He cannot say that okay, must elect means what? He will have to elect in a way that whether he will elect as a whole or he will leave as a whole. So, owner of the property must elect either to confirm such transfer or to dissent from it. So, what is the actually the election? Election is of the transfer, not of the option available within the instrument. Okay. So, it must be clear in mind that this election is about election of transfer or not transfer. Okay. Election, that means in instrument, in case of instrument, it may be possible that this instrument may have some plus point, some negative point. The option is not within this point. Option is here whether instrument you want to continue or no instrument. No instrument, that means you are not going to accept it at all. So, option at this place, not at this place. So, generally confusion it remains, okay, that election about benefit or not. So, election is not about the benefit or burden, election is about the transfer itself. Okay. So, whether he accept the instrument, he becomes entitled to the benefit, but he becomes bound to transfer of the property. That means, when he will elect this part, then automatically these two parts will come together, okay, burden part and benefit part. If he will elect this part, then nothing will come, situation will be as status quo, that whatever the things was, that will remain as it is. But if he is going to choose upper one instrument, that means he is going to choose the transfer, then whatever is within the transfer agreement, certainly it will come within that, and he will have to take the benefit as well as burden. So, the person electing must be owner of the property. Here it is important who will elect. So, owner will elect because there is a third party involved in this, third party is there, third party is Mr. A. So, this option is available only to the owner, because owner property is going to shift to the other person, and in lieu of that the proposer or transferor is going to give some kinds of consideration. So, the person electing must be the owner of the property. The word owner has been used in very wide sense in election, this election under 35. That means, not it is owner is not only the absolute owner of the property, that means all right vested with the property, but owner here it has been said that it may be the person with vested interest, okay, but also those who have who have vested interest and contingent interest, reversionary interest and remote interest in the property. So, number of types of rights are available. If the person is bearing those rights, we have discussed about the vested, contingent, reversionary right, okay, remote interest right, right in the property. So, in that case they will be entitled to transfer that rights. Transfer that right means what? They have no actual property with them. Actual property, they have a right related to the property, sometime enjoyment is postponed. Okay. In the case of just like prior interest with vested interest. So, in that case there is vested interest, but who is enjoying the property? Property is enjoyed by the prior interest person, but the person who is a vested interest, they can be called as a owner for this section, and this election right will be available for those persons. Okay. So, this is the fourth criteria. Then next one is this one more example has been added here. Okay. I give this third paragraph of the section says, yes, third paragraph and fourth paragraph of section 35. Okay. Third paragraph of the section says that a person taking no benefit directly under a transaction, but deriving a benefit under it indirectly need not elect, which I have already discussed, that the person taking no benefit directly under the transaction, but deriving a benefit under it indirectly. Okay. So, in that case he will have no right to elect. Fourth is that the person who in his own capacity takes benefit under the transaction may in other capacity descend from them. Okay. This is an important one. So, I have given example of it also. That means, a person if they are in dual capacity. Okay. So, election is available only for a person when in the same transaction the person is in the same capacity. If options are available in the dual capacity, then the doctrine of election will not apply. That means, what will happen? That if the person is with the dual capacity, then he may choose the beneficial from this one, and he may also choose beneficial from the another one, okay, because he is in the dual capacity. So, here there is a requirement that whenever there is doctrine of election is going to be applied, then person should or person must be or should be in the same capacity. Capacity should not change, then only election will apply. If the capacity will change, election will not apply. And so, for that purpose this example is that if the estate of Sultanpur is settled upon A for life and after his death upon B. Okay. A leaves the estate to D. A lived Sultanpur, this estate of Sultanpur is settled upon A for life and after his death upon B. A leaves the estate to D and 2000 rupees to B and 1000 rupees to C. So, suppose estate is X, okay, and it is left for A for life, then after his death for B. Okay. So, what is it that A leaves the estate to D, A leaves the estate to D and 2000 rupees, sorry, and 2000 rupees to B and 1000 rupees to C, 1000 rupees, and who is this C? C is B's only child. Okay. C is B's only child. So, B dies intestate without making any election shortly after the testator. Okay. B dies without making any election. C takes out the administration of the estate. C takes out all the administration of estate. Okay. Now, C has a different capacity. C is not merely the son of B here, but C is going to take the administration of estate B, and an administrator elect to keep the estate in opposition of the will. Okay. Now, this because C is the administrator, so administrator elects to keep the estate in opposition of the will. What was the will of A about X property, okay, and suppose here Y was the executor of the will, okay, owner of all the property, and X is the property. So, now all the property X is going to be vested to C. Okay. Then a C is saying that now this will remain with me because I am the administrator to keep the estate in opposition of the will and relinquish the legacy of 2000. This 2000 legacy has been relinquished by C. C may do this, yet claim under the will his legacy of 1000 rupees. Okay. That means, being an administrator of the property, he has a different capacity. Try to understand that C is now under the administrative capacity, as well as C is the heir of Mr. B. B dies earlier. Okay. B dies earlier. So, property has been taken by C. Okay. So, C is saying that now I will not pay, being an administrator, to these 2000 rupees. There is no requirement of this, but I can claim within that itself this 1000 rupees. Okay. I can claim this 1000 rupee, but not to this 2000 rupees. So, he can claim 1000 rupees, he cannot pay 2000, okay, being under different capacity. So, that there is a same transaction was same earlier, but due to the death of B, circumstances has changed, and due to the change of the circumstances, the responsibility and role of C has been changed. So, he is working differently in different condition. So, he will have that kind of the option that election will not apply in this case. Then where person elect to dissent, now he is not going to choose, but he is going to dissent from that. Any person is not opting it. Then what will happen? In this case, where the person elect to dissent, where the owner elect to dissent from the transfer, he will relinquish the benefits so transferred to him, and such benefits shall revert back to the transferor or his representative as if it had not been disposed of. So, in that there should not be problem in it. That means, if there is no choice has been availed, okay, so that will be revert back. Only thing is that there should not be a consideration has been used, okay. There should not be any kind of something positive state has been taken. So, only if the option had been given, and in that option he has not elected it, nothing is going to happen, things will remain as it is. So, this is a clear cut provision. Problem arises, okay, with use of that property. So, here one example is the farm of the Sultanpur is the property of C and worth of rupees 800. A, by an instrument of gift, professes to transfer it to B, giving by the same instrument 1000 rupees to C. C elects to retain it. Okay, C elects to retain it. So, C obtained this that he will retain this property, then nothing is going to happen. So, it is so there is no much concept in it. Problem always arises when the property or some consideration has been used by the owner. Okay. So, those kind of the things has been kept under the exception of this rule when he has not opted, but even though it will be presumed that it has been opted. So, it is the exception of that rule. So, what is the exception? It says exception is that the selection also contains the exception to the last preceding 4 rules, where a particular benefit is expressed to be conferred on the owner of the property, which the transferor possesses to transfer, and the such benefit is expressed to be in the lieu of the property. If the owner claim the property, he must relinquish the particular benefit, his farm, he forfeit the gift of rupees 1000. Okay. So, in that case what will happen? That this will be more clear in case of this exception once I will come to the mode. That means, if I have not opted this, I have not chosen it, but sometime it may be that your act or your conduct may be in implied nature. So, mode of election is going to become an important part to ascertain that whether this whether there is election or not. So, what is the mode of? Mode may be expressed or implied. Expressed may be in the form of written or it may be form of oral, whereas in case of implied, conduct is very important. Conduct is very important. Conduct will show that whether you have opted it or not. Okay. So, all the circumstances become very relevant, because the owner has not expressed something, but his condition is like that he has utilized the consideration. Okay. So, in that case it will be presumed that there was consent, but it was an implied consent. So, certain, in case of implied consent, certain things has been or certain things must be considered. First is that he is aware of his duty to elect. That means, owner was under this knowledge or aware about the situation that he has option available for election. Of those circumstances which would influence the judgment of a reasonable man in making an election. Okay. That means, those circumstances should also be known or must be aware with those circumstances, which will be very helpful in case of electing this situation. Okay. That means, something should not be hidden, something should not be hidden, something now the property, the price of property is going to increase or certain government policy is going to come, which was not known, and then in between something has been done by the agent, then all these things will negate this aspect. That means, election must be happen only when he is full aware with the situation, and then he is, because it is a deliberate act, it is not the fraudulent act by the agent. Okay. It is a deliberate act of the owner, he is going to choose. So, there must be a proper consent as well as proper information. So, he will be able to take proper decision for the election only when he will have all information with that property. So, that is the requirement. If he waives inquiry under circumstances. Okay. So, in these are the three conditions. If he waives inquiry under certain circumstances. So, that is also a kind of, it will go type of implied one. So, if two circumstances, there is presumption that he has knowingly accepted the benefit, that is important. This is the this is a kind of thing which may fall under the exception there earlier what we have discussed. So, what are these? That if without doing any act to express dissent, without 2 years of enjoyment, without doing any act to express dissent, that means, the person has not given dissent and using the property for continuous 2 years. That means, what has been offered by the agent, that benefit has been used by the owner and he is in continuation of that since last 2 years, then it will be presumed as a implied consent. Okay. Then now owner will be bound to execute his own part. Okay. Next is that if something has been done by the owner, that which will make the position impossible to go to the status quo. So, if that thing is going to happen and that thing is going to be done by the this owner, by utilizing it, which cannot reach up to the status quo, even in that case it will be treated as implied consent. That means, suppose in the lieu of certain money that some mines was allotted, okay, and the owner exhausted the mines, then now this exhaustion cannot be restored. So, meaning thereby it has been said that it is an implied consent for. So, this example say A transferred to B an estate to which C is entitled, as a part of the same transaction gives C a coal mine. C takes possession of the mines and exhausts it, he has thereby confirmed the transfer of the estate to B. Okay. So, this impossibility will also result into that. Now, come to the doctrine of apportionment. So, here it has been said apportionment may be by time under section 36 and may by estate, okay, under section 37. What is the requirement of apportionment? Apportionment is required about the division of the property, okay, division of the property or the rights accruing from the property. So, the main meaning of apportionment is division, shares. So, how it can be done? So, for that purpose this section 36 and 37 is. Okay. So, in case of section 36 which talks about apportionment by time, okay, wherever there is no time is mentioned in any agreement or transfer in agreement, then it has been presumed that it is on the day to day basis. So, 36 Act states that payment will be accrued over time and apportionment between the transferor and transferee based on the length of the ownership. The payment will continue to be made on the appointed dates during the transfer of any property that guarantees income via rents, annuities, pension, dividend or other periodical payments. So, that can be done through apportionment. So, this issue of apportionment occurs between the transferor and transferee. Okay. So, section 8 of the Act states that operation of transfer. So, unless a different intention is expressed or implied, a transfer of property immediately transfer to the transferee all the interest that the transfer is is then capable of conveying in the property and its legal incident. If the property is land, such incident include easement, attachment to it, rents, profit accruing after the transfer and all things attached to the earth. Okay. That means, all right has been vested. So, if there is a transfer of property and that transfer of property with all rights, if it is not mention any condition which is going under the different direction, okay, that is like the vested interest, contingent interest and all this. So, if there is a proper transfer, then from the same date right will accrue to the transferee and transferee will be entitled for that amount of money, that amount of benefit, okay, which may be calculated on day to day basis. So, for example, it has been said here that consider that A lets his property to C for rupees 1000 per month. C pays the rent amount at the end of each month. A sold his property to B on January 16. So, on January 13th, C will pay 500 to A and 500 to B. Okay. So, on 15 days, what is the total rent that has been apportioned, that means divided into. Okay. So, day by day it may be divided. Suppose it has been not on the 15th, it would have been on the 10th. Okay. So, it will go 300 and 700 like this. Okay. So, it will happen in that way. So, this concept of this apportionment in transfer is that when a property is let out to the many owners, okay, this is the case when it is lent out to many owners, none of the owner has the right to ask for a specific share of the rent or to demand eviction on the ground that he is the co-owner or is thus allowed to do so. So, mainly it is related with the apportionment but estate. So, this says that according in the light of section 8 of the Transfer of Property Act, all interest including rent, profit must be transferred from transferor to the transferee, and where the income is made on the daily basis, transferee would get the income on the daily basis starting on the day of the transfer. But if the income is not received on the daily basis and it is obtained in the form of periodic payment, the amount must be apportioned between the transferee and transfer. So, daily basis it is clear, but suppose something is coming in the after 6 months or monthly or after 2 months fortnightly, in that way up to that time when the transfer has been done, if it is monthly. So, just I give you the example. So, in that way it will be calculated. That means, time will be divided for how many days, what is the rent, what is the accruing benefit, that will be calculated and ultimately it will be divided between transferor and transferee. Then next is this apportionment by estate. Okay. apportionment by estate, it is 37, section 37. What is it that apportionment by estate means dividing all income generated by the property that is sold to several owners, okay, all rents, annuities, pension, dividend and whatever amongst them all. This division must be made according to the portion of the property of the ownership. So, rule of applicability of this is that after fulfillment of the following condition, that the person who is obligated with the duty to fulfill the burden under this section must have notice of the same. Obligation should be one that can be severed, and severance of the obligation should not end up increasing the burden of the obligation. Okay. So, these are the some conditions. So, it says that apportionment by estate contemplates the situation which the each share of the various owners income and rent is apportioned according to their specific share in the property. In tenancy cases, the tenant must be informed whether he must pay each owner separately if the apportionment is not done, or the tenant is not informed, the tenant is only liable singly. That means, in a house if there are co-sharer in the family, and if the family have co-sharer and they want a share of this property, that property has been rented out, and this rented out should go to the 2 or 3 brothers. So, in that way, if there is an agreement that okay, 15,000 rent is of this flat, so 5,000 should go to each. Okay. So, in that way it may happen, or otherwise if there is no agreement, then he will give 15,000 to anyone, and then after they will divide it. Okay. So, in that way it is apportionment of estate. Here time is not a factor, it is time is not a factor that you are dividing between transferee and transferor. Here the division of this benefit of the property is going to divide between the shareholders, so or the co-owners. Okay. So, these co-owners or this co-partner, not the shareholder, co-partners are going to get the share of that benefit. So, in that way it works. So, time is not a factor, factor is that there is a property is under the joint ownership. So, whatever is going to accrue from that property, that will be divided into joint owner. In joint owner, it may be sometime it may happen that portion may differ. Okay. There may be certain kinds of their internal arrangement, that one person is going to take 30%, another is 40%, rest is 30%. So, like that it will be divided. So, the illustration has been given: A sells to B, C and D a house situated in a village, leased to E at an annual rent of 30 and delivery of one fat sheep. B having provided half of the purchase money and C and D 1/4 each, E having notice of this, then must pay 15 rupees to B, rupees 7.5 rupees, C 7.5 rupees, D 7.5 rupees, and this must deliver the sheep according to the joint direction of B, C and D. So, in Lakshmi Naranappa versus Melotharaman, in this case the lessor had only a life interest and died a month before the rent of the half year was payable. Here there was no question of a transfer, yet the assignee of the lessor was held to be entitled to an apportionment of the rent for the period up to the death of the lessor. So, this is apportionment by estate, and in that way it has been clear. So, this is all about the apportionment of this doctrine of election, as well as apportionment by estate and apportionment by time. So, thank you so much.